Good afternoon, everyone. Welcome to our webinar today on the FTC's notices of penalty offenses and what they mean for you. I'm Len Gordon. I have the privilege of leading the advertising group here at Venable, and I am joined by an all-star collection of my partners who will help with explaining everything that's going on at the FTC on this issue today. Ellen Burge is a partner in our advertising and payments group who defends FTC investigations and counsels clients on these issues. Eric Berman is a partner in our advertising and nonprofits group who also counsels and advises and litigates on these issues. Alan Denton is one of our newer partners. He works in the financial services and advertising space, advising clients and representing clients in investigations and litigation. Alex McGarris here with me in New York works on FTC investigations, state AG investigations, other consumer protection matters on a counseling, investigations, and litigation basis. Melissa Steinman in our DC office is in our advertising group. She counsels clients across the country on advertising, sweepstakes, and promotions issues. And Shaheen Rothermel, joining us from Las Vegas today, is counsel in our group and works on counseling, litigating, and investigations in the consumer protection space. So thank you again for joining, and let's get started. There we go. Okay. So we're going to cover some background regarding the notices that the FTC sent out, the procedure behind them, perhaps the philosophy and policy behind them. And then we'll talk about the actual notices that the FTC sent out regarding endorsements, some compliance questions regarding endorsements and testimonials, which really cover all of the areas that the FTC is focused on, penalty offenses concerning for-profit education, and then penalty offenses concerning money-making opportunities. So what is a penalty offense? A lot of people had never heard of this before a few months ago. Under the FTC's penalty offense authority, the FTC can seek civil penalties against the company or an individual if it proves that the company or individual had actual knowledge that the conduct it was engaged in was unfair or deceptive in violation of the FTC Act, and the FTC had already issued a written decision that that conduct is unfair or deceptive. In the last few weeks, the FTC has sent out 3 different notices, one on October 6th to 74 profit colleges, one on October 13th to 700 companies involving endorsements, reviews, and testimonials, and one just yesterday to over 1,000 companies regarding claims for money-making opportunities. The purpose of these notices was to prove, if the FTC ultimately decides to challenge these in court, that the recipients of the notices had actual knowledge that certain acts or practices previously had been found by the Commission in an adjudicative proceeding to be unfair or deceptive. This authority comes from Section 5M1B of the FTC Act. And it provides that if the Commission determines in a proceeding under subsection B, that means an administrative proceeding, before an ALJ, who's actually an FTC employee, and that ALJ issues a decision that a certain act or practice is unfair or deceptive and issues a final cease and desist order, and that cease and desist order would then be typically appealed to the Commission, which sits as an intermediate appellate body. The loser of the appeal at the Commission can then bring a formal appeal to any U.S. Court of Appeals. So once that process is done, it becomes a final cease and desist order. This proceeding does not cover consent decrees. But if that proceeding ends, the Commission then can commence a civil action to obtain a civil penalty in a district court of the United States against a person, partnership, or corporation that engages in that act or practice. To do that, and it can do it against a person whether or not they were party to the original cease and desist action, but, and this is where the notices come in, the FTC has to prove that the person that they're suing had actual knowledge that such act or practice is unfair, deceptive, or is unlawful. The FTC can then seek civil penalties of up to $43,792 for each violation. If the action is brought against someone who is not a party to the original action, issues of fact, that is, did company X engage in this false statement? Did they make this false statement? Those fact questions are tried de novo, just like any other proceeding in federal court. In addition, the defendant there can ask the court to review determinations of law made in the original proceeding. So if the defendant wishes to challenge a decision by the commission that certain practices violate the FTC Act, as a matter of law, the defendant in this new civil penalty action can raise that issue. I suppose the FTC could also raise that issue if they feel that the appellate court somehow created a carve-out or a loophole, though I find it unlikely that they would do that. So what's the history on this? How did this come to be, and why haven't we heard about it for so long? This provision of the FTC Act was added in 1975 as part of the Magnuson-Moss Warranty Act. And that act, and this provision in particular, were meant to address criticisms that the FTC was toothless and that the administrative orders that it was issuing were nothing more than slaps on the wrist. And this was also meant to be a tool to address wide-ranging practices. Shortly after the statute was enacted, the FTC started sending out notices similar to the ones they've sent out in the last few weeks, targeting auto rentals, franchises, business opportunities, door-to-door sales, truth in lending, several others. In those couple of years, the FTC sent out over 2,000 notices, and they brought some cases in that area following that. The FTC, however, in the early 1980s, stopped using this authority. Instead, they began relying on their authority under Section 13B of the FTC Act, which authorized it to go to federal court to obtain injunctive relief, and interpreting that injunctive relief to also include equitable monetary relief. And over time, the FTC abandoned bringing cases in the administrative proceeding in almost all instances, and federal court became the predominant way in which the FTC challenged conduct and obtained monetary relief. In this century, it's been used once, this authority, dealing with bamboo claims that were being made broadly on Amazon and other places. So why the rebirth? Well, as I think most of you know, the FTC's authority to obtain equitable monetary relief under Section 13B of the FTC Act was gutted by the Supreme Court earlier this year. In anticipation of that, then Commissioner Chopra and one of his attorney advisors, Sam Levine, wrote a law review article calling for the reinvigoration of the penalty offense authority. And in their article, they targeted several industries or segments that they thought were ripe for use of this authority. Those were for-profit college fraud, that's their word, false earnings claims targeting workers, especially in the gig economy, online disinformation, including influencers and fake reviews, deceptive data harvesting, and illegal targeted marketing based on really FCRA-like issues, even though FCRA wouldn't be the statute that was allegedly violated. Once the Supreme Court gutted the FTC's 13B authority, I think this effort picked up momentum. As many of you know, Commissioner Chopra is now the head of the CFPB, but his former attorney advisor, Sam Levine, is now the head of the FTC's Bureau of Consumer Protection. So it's perhaps not a surprise that he is following through on the idea that he and his former boss floated. Let me talk to you briefly about some procedural issues and how this might work. If this case is brought, it will be referred to the Department of Justice. The FTC would likely do the investigation, reach a conclusion that there was a law violation, probably give the company a chance to settle. And if the matter does not settle, it will be referred to the Department of Justice. So this might help the FTC with some of its resource issues, because if they want to litigate a lot of cases, the Department of Justice is a lot bigger than the FTC in trying case, having the resources to try cases. These are civil penalty actions, so the defendant is entitled to a jury trial. Typically, the jury would make findings of fact, and the judge would determine the appropriate amount of a civil penalty. These actions would be subject to a 5-year statute of limitations, but the orders that serve as the predicates for these offenses can go back forever. This is the birth of the FTC. And if you look at the cases that the FTC cites in these notices, some of them are from the 30s and 50s. The order needs to make specific findings that the acts or practices challenged are unfair or deceptive. And I think that will be a ground for litigation, whether the conduct that's condemned in the FTC administrative final order is the same conduct that the defendant in this action is engaged in. In determining civil penalties, the judge will consider the culpability, the history of prior conduct, ability to pay, effect on the ability to do business, and such other matters as justice may require. So $43,000 is the ceiling. It does not have to be the amount of the penalty, and each day would be treated as a separate violation if it's a continuing violation. We've gotten some calls whether people think the FTC is going to use this authority to go into court and obtain asset freezes the way it was under 13B. I don't think it will. When the FTC got asset freezes using 13B, they talked about it as necessary to preserve the ability to obtain consumer redress. That's not what will happen in these cases. There will be civil penalties. So I don't think the FTC will be seeking asset freezes. And I think it'll be more a traditional investigation where the FTC sends out CIDs, conducts an investigation, and then tells the company they can either settle or get sued. And we know for a fact that the FTC is sending out CIDs in these industries as we speak. So with that, I am going to turn it over to the folks who are going to be talking to you about endorsements. So Melissa, Ellen, and Shaheen, please take it away.
Okay, thanks, Len. We'll just need you to continue the slide. All right, so our first topic, we're going to cover the notices that were sent about endorsements and testimonials. We're still waiting for that slide to pop up, but we thought we would do this one first, even though it was the second of the three letters, because the endorsements, the testimonials, user reviews, influencers are infiltrating virtually all industries right now. So we're going to talk about this one first. We'll take a quick pause as we talk about these letters to give everybody sort of some tips and reminders about complying with the FTC endorsement guides, and then we'll continue back on and talk about the two other main industries that have so far been targeted, but it sounds like more could be coming based on that list of the hit list, if you will, that we saw earlier. So here's a sample letter. This again was sent to over 700 national advertisers. So I guess if you got one, you're in good company, and if you didn't get one, you're lucky so far. But this is a pretty typical letter. It sets up what these letters and what the cases really set forward. The FTC will tell you it's at the very top of page 2 that they haven't singled out a recipient of this letter or suggested that you're actually violating the law, but this is a way to sort of blanket the earth and hopefully get some potential targets for them, I suppose, for some future action on that front. So let's move to the next slide, and I'm going to actually ask Shaheen if she would give us a summary of the types of claims that the FTC laid out in these endorsements letters that they think are problematic based on past decisions.
Thanks, Ellen. The notice of penalty violations were listed in the endorsement letters, and this is a list of them. And by background, these track pretty closely the FTC guidelines on endorsements and testimonials. So, for example, falsely claiming directly or indirectly an endorsement by a third party that was false. So including a fake review that was not actually an endorsement. Misrepresenting an endorser that's as an actual user, a current user, or recent user. In other words, a company cannot put an endorsement up in their advertising representing that it's an actual user or current user of the product or service when it's not actually. Continuing to use an endorsement without good reason to believe that the endorser continues to subscribe to the views presented. So if we have a reason to believe that the endorser's opinion might have changed or is no longer valid, the continued use of that endorsement in advertising, the FTC is saying, is unfair or deceptive. misrepresenting that an endorsement represents the experience, views, or opinions of users or purported users. So using an endorsement that does not actually represent opinions of real users of the product or service. Using an endorsement to make deceptive performance claims. And this is really a big one where we see advertisers often will use an endorsement or testimonial to make a statement that somebody believes is truthful and that's their true belief about the product or service that that might be deceptive if made directly by the advertiser. So it might not be truthful or substantiated in terms of the average results that people can achieve under typical use of the product or service. Failing to disclose an unexpected material connection with the endorser. We've seen this a lot in recent years where companies give, they compensate endorsers, so they give them payment, they give them free product, might be an influencer, a brand ambassador connected with the endorser, and the advertisement does not disclose the material connection, that payment, that compensation, the free product with the endorsement. Misrepresenting that the experience of the endorsers represents consumers' typical or ordinary experience. Again, conveying through an endorsement or testimonial this idea that everybody who uses the product or service will achieve a similar or the same result. Using fake positive consumer reviews, we've seen that in a lot of recent cases from the FTC for companies just use reviews that are simply, they're false, they're not real consumer reviews, or using positive consumer reviews without adequately disclosing a material connection that exists. And along those lines, there was a very interesting note in the cover letter that the FTC made, which was that positive reviews, it says, note that positive reviews are a type of endorsement, so such reviews can be unlawful, for example, when they are fake or when a material connection is not adequately disclosed. So we are now seeing the FTC move further into this idea of consumer reviews and not only endorsements and testimonials that are published on the advertiser's website, for example.
Okay, so
Go to the next.
yep, I think this goes back to us here, and actually, Melissa's gonna sort us through these cases. I can tell you that I don't think anybody in this room, and there's several of us, have read all these cases. They're quite old. There might even be some skepticism among us as to if they stand for what they're supposed to really stand for under these notices, but
You're taking my line,
what do
Ellen.
you take? Yeah, go ahead. I'm just amazed, but please go ahead.
Right. So, I mean, what the FTC did in the notice announcing that they'd issued these letters is essentially cite to the list of cases here. What they're trying to do here is, as Len mentioned, show that when they do try to bring these actions for penalties, that people had or companies had actual knowledge sufficient to bring cases for penalties. These cases are super old. The first one goes back to the time when I last had hair this long. Grew it out for the pandemic. And some of them go back to, the World War II era. So they're all older cases. They apply to, Cliff data is sort of a classic deception rule. It explains how Section 5 of the FTC Act applies as the standard for deceptive advertising and explains what is deception and what is puffery, but it applies in the mail order context. So, very, very old technologies, if you will, print advertising, in the National Dynamics case, but the classic advertising techniques, things like potential earnings claims. There's a schools case in here, things that we're all still dealing with, but maybe aren't the be all and end all in terms of what most advertisers are using nowadays. The FTC has spent most of its time in recent enforcement cases, really starting in 2009 when it added the examples about social media and online advertising to the endorsements and testimonials guides, focusing on newer technologies. These sort of go back to the older technologies, cite this established precedent to put the recipients and the industry on notice. It'll be interesting to see, how effective that is as a technique. But, certainly we've all had a lot of experience reading the examples, reading the guidance put out by the FTC since these cases came out, and can draw from there as well for guidance on, how to apply the endorsements and testimonials rules.
Okay, so let's advance forward. So, we're going to bring it back to today and just take a quick pause. We'll need some slides forwarded. Thank you. Next slide too. This is just a screenshot from the first page of the current FTC endorsements and testimonials guides. Still, this has been worked on over years, which we've talked about a ton and done webinars on this. But, over time, the FTC has updated this, has put in more modern examples. So we do still recommend sticking with this. You feel free to go back and read very old cases, but I do think the old cases are going to be representative, I guess symbolically, if nothing else, of what you should do today. So we're going to go take a moment and go over a couple of sort of today's most common use cases, I think, for maybe user reviews and those types of things. So moving forward to our first example. So we're going to talk here about reviews that your company is actually soliciting from customers. You might be reading them, you're selecting them, and you're posting them. So, this is feedback you'll get directly from your customers. You'll monitor the submissions. You'll decide what gets posted to your sites or what you put on social media, and you have a lot of control to that extent over what you're going to do. So, Shaheen, how about some compliance tips on what to do in this situation?
Sure. And this is one of the, I would say, more straightforward examples that we have here, which is an advertiser actively taking a consumer's statement or consumer's review and then porting that over and actively posting it on a website, on their social media, under the advertiser, the company's branded social media platform. So that's going to be subject to all of the endorsement and testimonial guides. So first of all, the review that's being posted by the company cannot convey an express or implied representation that would be deceptive, false, unsubstantiated if made directly by the company. Again, the company has to have adequate substantiation to support claims that are made in the review. So the FTC's made very clear their opinion that if you are using a customer review, you can't use that review to make a claim that you would not be able to make directly, including claims that you do not have substantiation reflect the average user consumer's experience with your product or service. So along those lines, the reviewer's experience that is being posted must be typical of what other customers or users could expect. Otherwise, the advertising should include a clear and conspicuous disclosure of the typical results. The FTC has said results not typical is not sufficient, that the disclosure needs to say what people can expect using the product or service under average or typical conditions. Making sure that the review is from an actual customer and that you still have reason to believe that the reviewer is a bona fide user of the product or service. That's a big one because a lot of times we see reviews that a consumer might have changed their mind or something like that. So ensuring that you go back to that reviewer, getting permission to use their review, and ensuring that they still agree with the comments that are being made in the review. A lot of times what we'll do is we recommend having an actual declaration or an affidavit giving the company the permission to use that review in their own advertising, and also having that consumer agree that they still believe it and that does accurately reflect their opinion. If there's any material connection between the company and the reviewer, that needs to be disclosed. It might be an employee of the company. It might be a family member of an employee of a company. It could be a paid review. A lot of times sending a customer a product, say, hey, try this and give us a review. That's a material connection that needs to be disclosed when we're taking those reviews and publishing them on our advertising. be careful of cherry picking only good reviews. A lot of times what we'll see are companies that they'll say that, we have these good reviews, or these accurately reflect our reviews. And the FTC has sometimes taken the position that doing that might misrepresent the overall view and reviews that are actually out there, the body reviews that are out there on the product or service.
Okay, let's go to the next example. All right, so there is now a wide variety of automation tools that you might use to solicit reviews and post them to one of your web properties. You can get sometimes hundreds or thousands of reviews up on your site this way. It's high volume stuff. It can be difficult and challenging to read all of these. It's very much automated. We're sort of getting those up there very quickly, but yet it's probably not impossible technically to read all of these reviews and to maybe make sure that we're not letting things go in there that are I'll pick the easy weight loss example, saying, hey, I lost 10 pounds in a week or whatever it is. And it's sort of just littered with those types of comments that maybe don't accurately represent the product. So Melissa, do you maybe want to take us through what can we do to sort of strike a balance between what we can and can't review here?
Yeah, I mean, I think that when you're using sort of a platform to collect and republish reviews and ratings like that, I think you need to think before you go and do that republication about whether you are actually able to do the monitoring and the work so that you can do that, remembering that when you republish, you are taking on certain responsibilities, and you are potentially being viewed as adopting the claims in there. You can add a disclaimer, but still there is a risk out there. There are crawlers, there is technology that you can use. There are third parties that you can use to monitor those reviews, but you are sort of taking on a responsibility. There's stuff you can do at the front end as well, with the people, consumers, that sort of says, this is what's okay and what's not okay in a review. Of course, that won't be a perfect screen, but particularly if you are incentivizing reviews, you need to make it clear that, hey, you don't have to give us a good review, but you do have to disclose. If you're filtering out negative reviews, that's going to, potentially be problematic there as well, because that's going to be skewing the reviews to the positive. And particularly if you're then going to be making claims based on, hey, all of our 50% of our users love our product, you've skewed anything that can be used as the basis of a claim. You also may be, I do a lot of product safety. You may be missing complaints that could be very serious. My product caught on fire. And so you need to think about whether you're going to be sort of crawling for product complaints that could potentially give rise to product safety issues, from a reporting to the CPSC point of view and from a product's liability point of view. So some things to think about, from a review automation front. There are some additional tips I may have forgotten there, but
They're there.
They're there for
They're
you.
there. It's quite, that's food for thought, really. It's things to think about, and I'm sure you all get the slides, but let's keep moving in the interest of time to our next example.
Exactly.
So, okay, so here, this is the one that we get a lot of questions on too. You see one of your customers bought something through a third-party retailer, maybe Amazon or Target, and they posted a review, and it's a really great review about your product, and you want to pick that up from Amazon and move it over to your site and use it. So this is really a little bit more on the reposting here, but Shaheen can take us through this situation and what to do.
Sure. So when you repost a review, and as Melissa said earlier, you could be seen as adopting the statements that are made in the review and taking responsibility for the review as a whole. In other words, if somebody said anything about it, making sure that they're still a user, complying with those endorsement guides that we've already talked about. So when you as an advertiser or company take that review and port it over into your own advertising, I think that's a situation where the obligations from the FTC standpoint are going to be much greater than having people going off and saying whatever they want about your product on Amazon or Target. The wrinkle in all of this is that statement that the FTC said in the letter about positive reviews being a type of endorsement. So such reviews might be unlawful in certain instances when they're fake. I think, however, and I think we've all talked about this, and the reality of the industry is that if you have no connection with the consumer, you haven't solicited a review, they're not a family member, they're not an employee, you haven't sent them free products, they just go out and buy your product and post on a third-party retailer site, and you don't interact with it or adopt it or repost it anywhere, it would be very difficult, I think, for the FTC to hold that advertiser responsible for statements and reviews being made on that site.
Okay. All right, so we're going to go to our very last example, and these are third-party review sites, and we won't name any, but they're out there, and these are ones that sort of seem to offer an objective and usually positive evaluation. Some of these types of services have popped up, maybe not directly in FTC cases, but certainly have been discussed as potentially being used by an advertiser to come out to the marketplace with 5-star ratings that may or may not be completely accurately clean there. So here, the tips here are really just more of sort of, the FTC has viewed this in some cases as stuffing the ballot box, and just looking here to see, can you really do this? Store credit is one of these things. I don't know if you want to talk about credit, because you're often talking about giving somebody in-store credit or compensation in the area of sweepstakes, but here maybe the same thing or for a review. It just really goes back to the material connection disclosure.
Sure, any kind of situation where there's a material connection, where there's compensation for a disclosure, where your employee is posting reviews, where an agency employee may be posting reviews. There's a whole bunch of cases where companies have gotten in trouble with the FTC, where the agency employees got a little excited and started posting reviews without disclosing their connection. So it's important to have guidelines that make it clear for your employees, family members, agency employees that they have to disclose. That's a material connection. So some things to think about as well when you're talking about reviews. And of course, there have been a number of cases where there's been compensation for reviews and there hasn't been proper disclosure, and there have been FTC settlements in that area.
Okay, so let's go to our last slide on the topic, and then we'll resume talking about the penalty offenses. But just to wrap it up with compliance guidance, Melissa, this is actually a good one for you too, because you write a lot of policies and influencer policies, and have dug into agreements and put even language in agreements, but just maybe some tips to round us out for running a compliant user review type of marketing program.
Sure. I mean, it's important to have clear, we all have hopefully clear influencer policies now, and where, you have it clear for your employees, for your agencies, what the expectation is there with regard to disclosures. But it may be less clear what the expectation is when it comes to how to solicit and promote user reviews, and what kinds of disclosures there must be when there are connections, whether it's providing compensation or, like we talked about, employee disclosures, agency employee disclosures, and the like. And that should go to internal policies and agency policies and making sure that your agency has a policy. So, those should cover things that we've been talking about, like the disclosures, making sure, how do you confirm that a reviewer is a bona fide user? How do you confirm that, that's your reviews are up to date, that if you're going to adopt claims, that those claims are true and substantiated. Do you have standardized language for material connection disclosures? If you send out compensation, do you say, some sort of gift certificate to a great customer? Do you say something like, hey, we love you, here's something, you're our best customer, but you don't have to write something, but if you do, please to disclose, that sort of thing. Are you monitoring disclosures? Are you maybe terminating third-party relationships where they're not compliant, which is an express expectation from the FTC? When you have review sweepstakes, are you making them disclose that sweepstakes entries are material connections, that sort of thing? So it's important to make sure that you are complying on sort of all fronts with reviews as well as influencers.
Okay, so I might actually just turn it back to Len or Alex in New York for a second to tee up the next topic.
Thank you, Shaheen, Ellen, and Melissa. Alan,
Alex.
Eric, and I are going to cover the second notice that went out, which actually was the first one to about a few hundred companies in the education marketplace. We'll let Alan and Eric kick it off.
Okay, so next slide. Let's frame the discussion first. So the first question that we had when we looked at these is why for-profit schools in the first place? And as Lynn already hinted at, for-profit schools and this industry was a priority of the departed Commissioner Rohit Chopra and his deputy Levine, who is now heading the Bureau of Consumer Protection. And for former Commissioner Chopra, it goes back to his days as the student loan ombudsman at the CFPB. And he has been interested in this industry and has made public statements about this industry for years. And now, even though he's left the FTC is looking for ways, in my view, to find ways to discharge student loan debt, which Chopra and others at the FTC view as excessive. And so in doing that, they have made fairly inflammatory public statements over the years about for-profit schools. They've called the model scams. They've alleged that people are frauds. They've called them bad actors. And Chopra has specifically said that he wants to, quote, set the stage for canceling student debt. So all of that frames the letters and informs, why these letters were sent. But why were these particular schools chosen? Well, this is, again, part of an industry sweep. And the idea is to cast a wide net, and hopefully they will, in the FTC's view, capture some actual targets who will now have been on notice and be subject to the FTC's penalty authority. So we've established that the FTC doesn't like the model. They want to look for ways to discharge student loan debt. So how do they get there? And that brings us to the letters. Next slide, please. In a word, if you are the recipient of one of these letters, they are in a word generic. They cite only to quote previous litigated cases, and then they state that certain practices are deceptive. To actually find out what practices are deceptive, you've got to click a link and you've got to read some cases. Well, thankfully, we have done that for you here today. And so on the next slide, we are going to talk about the cases that the FTC has cited. As you will see, the FTC is relying on some very old cases to potentially blast the industry, and primarily they are before the FTC's penalty offense authority existed, and they are not especially specific. Let's start with the McMillan case. This is a 1980 decision The facts are essentially that the Macmillan Company provided correspondence courses for vocational training. They did that through oral sales and through print media. And the complaint claims that Macmillan made the following misrepresentations. They claimed that there was high demand for employment in the field when there was not. They allegedly claimed that there were high wages to be had in their correspondence course fields and that there were not. They claimed that the graduates were qualified to receive certain types of jobs and they may not have been qualified. And then they also claimed that there were strict admission requirements to the correspondence programs and there were not. And then for an unfairness practice, they said that there was no opportunity to cancel courses that had allegedly little to zero value. And the commission essentially adopted what was described in the complaint. In the order, it was explained that Macmillan could not make the misrepresentations that were described just now, that they had to provide a disclaimer that a job was not guaranteed, that they had to provide data on employment percentages where claims about employment was made, and that testimonials had to state that experiences were atypical if they were indeed not typical of the normal graduate. And then finally, that the company must not misrepresent consumers or graduates' financial obligations and their ability to cancel courses. So the takeaway here is not really in the specific prohibitions because the language is very broad and it's designed to be very broad. And that's why the FTC has cited these cases, because it can capture a lot of conduct that the FTC doesn't like. So let me turn it over to my colleague, Eric Berman, to discuss the other cases and to talk about, kind of dive deeper into the specific practices that the FTC is concerned about.
Great. Thank you very much, Alan. I'll talk about the other two cases that were cited in the notice to for-profit schools, both even older than the Macmillan case that Alan just talked about. I don't have a joke about having hair. If I were alive back then, I probably would have looked like that picture of Eisenhower. The Eastern Detective Academy, that was a complaint brought against the academy itself and one of the academy's officers. In 1969, the final commission order was issued in 1971. This was a DC corporation that advertised courses to people seeking jobs as detectives, private investigators, and undercover agents. We can generally group the alleged misconduct into four buckets, and there's a lot of overlap with the alleged misconduct in the Macmillan case that Alan just mentioned. You have claims about job demand and employment prospects. The academy advertised that trained undercover people are, quote, always in demand. There were advertising claims about how successful the job placement service was, that it had placed hundreds of people in investigative work the prior year. Claims about the type or quality of jobs available. The commission in its final order really leaned on this, that the advertising sort of portrayed the academy as almost a conduit to exciting, high-paying, almost glamorous careers in the private detective and investigation space. The commission cited a newspaper ad that said, "You may not become rich and famous like James Bond, but many of our graduates were placed in interesting, well-paying positions." Claims about the academy's credentials. So we're talking about the size and qualifications of its staff, what types of training students got, like handgun training or polygraph machines. We talked about testimonials earlier. Some of these claims were made via testimonials in academy brochures, ostensibly from graduates and from businesses that employed academy graduates. In fact, under oath during the administrative trial, the head of the academy admitted that he himself wrote some of the testimonials in the brochures. So talk about a material connection. And then finally, enrollment practices. So we're talking about, the academy having students sign enrollment contracts that were ambiguously worded, made to look more like enrollment applications rather than contracts with payment obligations. It's an old case. It's an interesting case. The FTC actually brought this case not only under the deceptive and unfairness prongs of Section 5, but also as an unfair method of competition, also prescribed under Section 5. And the commission didn't adopt all of staff's allegations, but adopted most of them in a final order that proscribed misrepresentations about job demand, how many graduates have obtained work at desirable wages, misrepresenting the performance of the placement service of the school, and then ordering some protections around the contracting practices. The oldest case is against the National Institute of Practical Nursing and two of its officers. That was a complaint brought back in 1949, so we're in the post-World War II era. The final order was issued in 1952. The challenged advertising centered around, again, misrepresentations about job opportunities, demand, advertising saying that there's a desperate shortage of nurses that provides opportunities for you. The quality of training offered. This was advertised as complete training. The commission focused on the word complete. This wasn't complete training. This was classroom training. These people were, graduates were not coming out of the program as licensed practicing nurses, but rather as nurses' aides. The Institute's track record of placing graduates, and importantly, misrepresentations about associations with potential employers, where there were advertisements saying that the academy's diplomas and certificates were recognized by Georgetown Hospital, and that the doctors connected to the school would certify the qualifications of those graduates. So again, there was a disparity between what was advertised and what was provided. Generally, graduates got lower paying jobs. There was no affiliation with Georgetown Hospital, for example. And so the commission entered a final order preventing such misrepresentations, and really getting granular here, preventing misrepresentations using the word complete or licensed nurse. So Alex, let's go to the next slide, please. Thank you. So what the FTC did, and it did this with endorsements and with the money-making notices as well, is it culled from these cases categories of conduct that it considers violative of Section 5 and subject to civil penalties for any for-profit school that's found to engage in them. You could see these up here. These are right in the notice. We can go through them quickly. Misrepresenting the demand for consumers who have graduated from or completed courses at an institution. I would include here, by the way, not only consumers who earned a degree, but people who earn certificates or perhaps get professional accreditation or credentials from a trade association. Misrepresentations regarding employment prospects. I think we could probably combine numbers 2 and 3 here. How easily will your students, graduates, learners, what have you, get a job, and what types of jobs will they get? Misrepresenting how many of your students have gotten a job in their chosen field. Number 5 is, these are all important, but I think number 5 is uniquely important. Misrepresenting how much money your graduates will earn when they graduate from your program. This is significant. It obviously goes beyond traditional for-profit higher education institutions. It touches on practices like MLMs, business coaching, stock trading, real estate investment, practices that I think Len may talk about in a few minutes when he addresses the FTC's notices issued yesterday. Misrepresenting qualifications needed to obtain a job. In the nurses case, for example, the advertising said no high school education needed. That was untrue. My commentary here would be that the commission has traditionally been protective of populations of consumers that it thinks is uniquely vulnerable to what it thinks are deceptive or fraudulent practices. In the 50s, 60s, and 70s, that vulnerable population was often uneducated people, the gullible, this was before the reasonable person standard. But today, I think we could look at veterans, members of the military, non-English speakers. as populations that the commission is protective of. In fact, veterans were mentioned in one of the blog posts when these notices were issued. And then finally, misrepresenting the institution's ability to help students get a job. And I would say not only the existence of job placement services, which is mentioned here explicitly, but misrepresenting relationships, associations, affiliations with potential employers. Going back to the nurse's case about the misrepresentation about Georgetown Hospital. And as many of you know, the commission has more recently challenged in non-litigated cases a similar alleged practice of misrepresenting relationships with large, prestigious employers. So this is clearly a high enforcement priority item for the commission. When the commission sent out these notices, Chairwoman Khan said that for-profit schools had been preying on students with impunity. I would respectfully disagree with that characterization. As Alan said, this has been a high priority for the commission for years. And let's not forget, it's been a high priority for state AGs as well. And I think we can expect to see some coordination on that front. So the point is, compliance is really key. And that's what Alex will talk about. So I'm going to hand it over to Alex.
Thank you, Eric. Let's see if I can get these slides to work. Okay, one slide. So what do you do if you receive one of these notices? And what I'm going to discuss for the next few minutes, I think, is equally applicable and advisable for companies that may have received yesterday's notice, which Len will address in the last segment of the presentation. But those went to multi-level marketing companies and others that offer what the FTC is calling money-making ventures and opportunities. With the stakes of non-compliance this high, I think it behooves every school who received one of these notices to take a step back and conduct a very targeted gap analysis to identify areas that present compliance risk, and then come up with a plan to prioritize those risks and address them. We'll try not to be Chicken Little on this presentation. I don't think the sky is falling, but I think what is obvious is that the stakes have intensified considerably given these are now penalty eligible. And so first and foremost is taking a step back and looking at the school's compliance management system and ask yourself some really hard questions. First, are you staffed with the right people and with enough people to ensure that there is sufficient compliance oversight over your advertising copy? Second, does the school have clear policies with respect to advertising, and in particular, with respect to what can and cannot be said about job and earning prospects and about your graduates? Third, how is advertising created? I think, it could span the spectrum of everything being done in-house to everything being outsourced to content creators, affiliates, and networks, or some kind of hybrid in between. But to have a good compliance program, we really need to have a good understanding of where advertising is created and who approves it. Is that person's training sufficient on the school's internal policies, but also these general concepts of deceptive or misleading advertising? And how are those that are on that creative side, that are creating the content, how are they getting information and data about the school, its courses and offerings, and its graduates? You need to have a very clear approval process, whether it's pre-clearance, having certain copy, statements, images pre-approved, and then allowing those third parties or employees to use them, or some sort of process for clearing every ad uniquely before it goes live. Second, you need to know what's currently out there. You need to do an audit. Obviously, depending on the universe of potential advertising out there, it probably will need to be some sort of sample. But first and foremost, you need to have kind of an inventory of where your ads are. I live in Manhattan. Every subway has advertisements for for-profit schools. Don't forget things like that. You potentially have tentacles of your advertising in many different places. You need to have an understanding of where your ads are in order for you to audit them appropriately. When doing an audit, you need to look at the ads like a regulator would. I know this is really hard. It's hard for us too, but that's our job. You need to wear that hat. What are all the possible takeaways a consumer may have when viewing that ad? It's not just what you intend to say, but it's all any reasonable interpretation. And you need to back up each of those possible takeaways. The level and nature of the substantiation you would need to back up a specific claim is very fact intensive. It depends not only on what you're actually saying, but the images that are used in the ad, the context around the ad, such as the content on the website around where the ad is placed. That all goes into what the impression is that's being given. And again, each of those takeaways needs to be substantiated. And this is really key for using a native advertising strategy. So if you are working with influencers or placing your ads on websites that are designed to, a lot of content, editorial content on schools, education, the type of maybe job market that you are targeting students for, all of that context is going to be kind of important in order to understand what substantiation you need for your ad. Third, vendor management. If you're relying on third parties to generate leads for your school, you need to ensure you're working with responsible networks. You need to draw very clear lines on what can and cannot be said by affiliates. And you need to give them data and information that they can work with. And we'll talk about data in a second. I think that is probably the most important thing we'll talk about today. And then finally, and we're going to say this, you need to monitor the ads out there. And Melissa talked about some technologies you can use to do that if you're working with a vast network of affiliates and other lead generation providers, but you need to have an understanding of what's out there. Again, none of this is new, but the stakes are very high. If you're purchasing leads and you don't know what was said to that person before you talk to them, you're treading in very dangerous waters. You're gonna have to assume that they were promised things, and you're gonna have to kind of work from an assumption that you need to clarify and make very clear what your program includes and doesn't include, et cetera. And finally, lawyers get a bad rap for always saying no to everything. If you want lawyers to greenlight advertising copy or strategies, you need to give us something to work with. And that means solid, reliable data about either the job market or about your graduates. This is really resource intensive. It takes a long time to do. I think that management at your respective schools needs to consider this type of data analytics as important as the analytics that's used to target potential students. I think the more information that is verified, credible, that you give the people that make ad copy, they could be creative and come up with good ways to create ads that will get eyeballs, but also don't put you into trouble. The last thing I'll say about data is data could be manipulated. And so you need to be really careful about what you're relying on. I'm thinking of an example. I think it was a private lawsuit against a few law schools a few years ago about kind of the advertising that they had distributed about their graduates' jobs prospects. And what was uncovered was that the statistics about how many law students were placed in jobs included jobs at the law school doing non-legal work, right? So their graduates were being hired to work in the career office, and they were counting those people as employed lawyers. And ultimately it was found to be deceptive, because even though they had data to back up that 80% of their students were employed. They were not employed as lawyers. And so you need to really be careful when you do have data, which is first step, is that you understand what it comprised of, and that you can, kick the tires before you use it. And with that, I'll turn it over to Len, who's going to talk about yesterday's notice that the FTC issued.
Thanks, Alex. And thank you, everyone so far. This has been really great. I think as you listen, you should probably be thinking a little bit, how are some of these 1950s orders going to deal with things like user-generated content and native advertising? And I think that's where the action will be in the investigations and litigation. I wanted to note that the endorsement notice went not just to 700 companies, but on that list were several advertising agencies. So the FTC is going to be seeking to impose ad agency liability necessary where it feels it's necessary. And I think one of the things you're also seeing here is that there's obvious uncertainty about, almost 2,000 companies have gotten these notices. That creates tremendous uncertainty. And it's quite clear that the current FTC is using uncertainty as an enforcement tool. They're doing that on the antitrust side, where they've revoked certain guidance about what conduct is permissible. They've made it less clear when the merger review process ends. And I think here they're trying to use uncertainty to curb conduct that they don't like, recognizing that they cannot pursue cases against 1,800 companies all at once. So I think that's just something to be thinking about as you're thinking about these things here. Money-making opportunities is an area where the FTC has been active, not just in for-profit schools, but multi-level marketing, the gig economy for gig economy workers, businesses that sell coaching on how to make money in real estate or in the stock market, business opportunities, franchises. The Penalty Offense Authority does not displace the business opportunity rule or the franchise rule, and I think if someone's violating those, it's probably more likely the FTC will pursue those using those rules because there are ample other tools available to it. But for coaching cases, multi-level marketing, I do think the Penalty Authority is something you're going to see. Which cases we'll have to wait and see. Again, to just sort of highlight, I think sort of this grows out of not just the loss of 13B, but really a perception that Sam Levine has talked about, that Chopra has talked about, that even the penalties and the redress that the FTC was getting under Section 13B wasn't a sufficient deterrent. The law review article talks about, well, you're just having to give up the money you took in, and so you're no worse off, sort of completely ignoring the fact that you have a cost to operate your business and to buy inventory and raw materials. So again, a very high level of hostility on these areas, and that cautions that you be careful. So the guts of this notice is that you can't make earnings claims that are false, misleading, or unsubstantiated. And they point to several litigated cases that deal with these. The McMillan case we've already talked about. And the themes in these cases are similar to the ones that we just heard about for the for-profit area. I think one of the things that's going to be interesting is typicality disclosures and whether those are effective. The endorsement guides that say that, results not typical was not the law when these administrative actions were considered, and how disclosures in those cases are dealt with and how they're used now. There could be some fairly significant factual gaps that will be, again, grounds for litigation or investigation as these cases move forward. I'm not going to spend a lot of time going through these cases. The facts are really antiquated. I mean, we're talking about things like rug weaving and selling encyclopedias door to door, as exciting as those things are. And my favorite is the Waltham Watch Company, which was a business really teaching people how to sell counterfeit watches. So we won't spend a lot of time on those. But again, the notion is, if you're going to be making earnings claims with this current commission, you've really got to back them up. You've got to have data. Again, one of the litigated issues I think is going to be: are you claiming that people will or are likely to make money, or that they can make money? that distinction between likely and will versus can is huge, and that's where disclosures and disclaimers may become really important. I mean, that's an issue in cases that are getting litigated now. I think it'll be even more so when you're trying to pin these old cases on new conduct. And then I think another issue is going to be the level of substantiation that is acceptable. If you know that some of your students can take what you've taught them or can take the tools that you sell them and make a very good living, not all of your students, but some of your students can. At what point is that adequate substantiation? And that's where, as Alex was talking about, it's really important that the language in your claims matches what you have in your substantiation file, just the way you would if you're marketing a dietary supplement. If some people can lose a pound a week, you can't be telling people, and one person lost 8 pounds a week, you can't be making the claim that 8 pounds is your typical weight loss. And it's the same thing with money making. Your substantiation and your claims need to match up. And I think that's even more so now. In addition to the money-making claims, there are a bunch of cases that criticize and condemn, I'll call them false sense of urgency claims, things that, the training is only offered to a select few, that you have to act now, that the amount of training or work that's necessary is misrepresented. And some of those may be material, some of those may not be material. And again, I think scrutinizing those older cases that the FTC is looking at and really determining what exactly was found to be deceptive there and how that relates to the claims that are being made in the market now is going to be of vital importance, and really, again, where the action is going to be. So that's it for now. I don't know, do we have any questions, Alex? So if you have questions, send them to us. We will do a recap. We'll take the questions that any of you have sent. We'll push out written answers to this. I expect that next week we may get another notice. They seem to be sending one a week. I don't know which one that's going to be. This one surprised me. I thought some other areas might come first. We'll see. But the commission is going to be incredibly active. They've got an awful lot going on. They've got all these proposed rulemakings they're thinking about. They've got they're talking about using consumer protection lawyers in merger review to ferret out consumer protection issues in companies that are considering mergers. So there's a tremendous amount of activity in the privacy space. So how all of these conflicting priorities get triaged remains to be seen. But clearly, these notices are one way the commission is trying to deter conduct, and also they think to make these cases easier. Whether that actually proves to be the case remains to be seen. Thank you to our panelists who did a great job covering an enormous amount of material. Thank you all who attended today, and have a great rest of the day. Thank you very much, all.